Let's talk about the transfer on death. Back in 2016, California enacted a bill to help property owners avoid probate when passing away. Remember, I talked about this before. Holding your real estate in a trust is still the best way, in my opinion, that you should hold title. Reason being is that if you pass and your heirs have issues or they're fighting, it clearly states out in that trust who gets what. Let's talk about the transfer on death deed and why people use it. If there's not a lot of assets and you want to avoid probate, this is a simple way of estate planning for somebody in that situation. Another reason the transfer on death deed is really attractive is because you don't have to add anybody to the title in order to convey it. But let's get into what is required to do this properly. The first thing is that the transfer on death deed needs to be notarized. Also, there needs to be 2 witnesses to that notarization, and that's not common on other documents. Another thing is, once that document is executed, it needs to be recorded to within 60 days of you signing it. Then upon death, the beneficiary has to notice the trustor's heirs with the death certificate and the transfer on death deed. The third thing, the heirs or the beneficiary that got it must record an affidavit of death of transfer under a revocable transfer of trust deed. That's a mouthful, right? That is essentially going to be putting the title onto the beneficiary's name. The fourth thing, and probably the biggest, is that the beneficiary that now owns the property, they cannot sell for up to 120 days. If you're going to be selling, remember to do that immediately to start the timeline. I hope this information was helpful, and remember, on all your real estate transactions, choose Jamie at Chicago Title.